Hello, ladies and gentlemen. Welcome back to Salsa Kings Live. We are here for episode 21 for a very, very, very special episode, something that actually is really, really important, not only to me, but dance professionals, I feel, everywhere in the country. This is definitely something that I don't think it gets talked about enough simply because we perhaps don't know any better. But obviously, of course, we're always trying to bring value to all of our viewers. So in this case, we have a professional a lawyer, Eric Gros-Dubois, who actually is a founding partner of his own law firm. Actually, growing up in Dallas, Texas, has been in Miami for 9 years. He opened up his law firm about 5.5 years ago with his team of 10 lawyers. And we're talking about something very specific here, which is copyright law and intellectual property to what ultimately allows an artist, or in our case, a dancer, to have the room or the platform to create something that they can officially call theirs. The reason why all of this kind of got started, if you will, we were actually a team of, or not a team, but fellow dancers of ours actually ended up sharing a video on Facebook, which I would actually like to share with you guys. It's an 8-minute long video. Feel free to look it up on your own. We're not going to watch the whole thing. But in summary, I'm not sure if you guys are familiar with the very, very popular video game known as Fortnite, which has taken the country by storm as far as for sales, as far as for popularity amongst kids. And it's basically a cartoonish fighting game, similar to your Call of Duties and stuff like that. I mean, you have different weapons and stuff, and you're going out basically killing each other, if you will. But what's unique about this game, and particularly where it affects us, if you will, is that there is a portion where you can actually go about spending real money in exchange for, I think, credits in this game, where you can purchase new gear for your avatar, for you basically, and you can also be purchasing dances for victory. So like, let's say, for example, you could set a default for whenever it is that you win a game, it does a particular dance move. Now, what's controversial about this is that Epic Games, the company, has been using dances that have been popularized by famous artists in the past. So now we start to create this controversy where, is this something that another company can actually use for profit? So I want to go ahead and take the time here really quick. I want to show this to you guys so that you can go ahead and make your own judgment on this. So I'm going to go ahead and bring this up here and see if we can go ahead and get this playing here. Give me 1 second. Beautiful. All right. So check this out, guys.
Could Fortnite be held legally accountable for making money off their dances? Beyond the courtroom, is it just ethically wrong? And can you copyright a dance move? This question has become a topic of debate with the rise of Fortnite.
So there you have it, ladies and gentlemen, the concept or the idea in which the debate of being able to copyright a dance move. So again, we have Mr. Eric Gros-Dubois here live with us. Thank you so much for your time, boss. Thank you very, 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 very much for spending 5 seconds with us, for us little people, if you will, just trying to make a living for ourselves, man. And I feel that this is a really, really big deal. But first and foremost, before we even go into that, please tell us a little bit about yourself. Tell us why you chose to do this for a living, et cetera, et cetera. I'll give you the floor, brother. I'll give you the floor.
Listen, I thank you very much. I hope you can hear me. So again, my name is Eric Gros-Dubois. I'm here in Miami, Florida. It's EPGD Attorneys at Law. I have a partner, Oscar Gomez, and we're trying to build. I started the firm 5.5 years ago, and we're trying to build a full-service business law firm where business owners come, and then half the firm we keep them out of trouble, half the firm, if they get in trouble, we go fight for them. And on the keeping them out of trouble, and then sometimes on the going to fight for them, is dealing with intellectual property. So just as a quick summary for those of you out there who maybe have never heard the clear definition, we really think about 4 different types of intellectual property. We think about patents, which are like your inventions, like you invent like a thing. We think about trademarks, which is your branding, which actually is a quick little corollary. We'll get into this later, but you can't copyright like a football move, like when you score a touchdown and you do like your trademark move, but you can trademark the name of the move. So like Tebowing, remember Tebow? So so he trademarked Tebowing. He couldn't copyright the move, which is, I guess, the whole point of our debate today. But he trademarked the name, so he could put it on apparel. He could sell T-shirts or whatever. Then we have so we got copyrights, which is your branding. We got trademarks, which is your branding. Copyrights, which is anything creative. We think about photography, videos. We think about if you write something. And lastly, we have secrets. So those are like our 4 areas of intellectual property. And so just real quick, you mentioned it. Here are some of the artists that are alleged to have been infringed upon by these guys, all right? So we got the 2004 Snoop Dogg video, Drop It Like It's Hot. The emote, which is what they're called in this game, Fortnite, is called Tidy. We've got Alfonso Ribeiro's Carlton. You guys remember from the Fresh Prince of Bel-Air, which is super relevant because today he filed his lawsuit. So today in the Central District of California in federal court, Carlton from the Fresh Prince of Bel-Air sued the same company.
Whoa, back up. Okay, whoa. Okay, so time out. So the people in this video, they actually made a motion against Epic Games as well. The what's his name? 2 Milli?
Right. So 2 Milli, our guy 2 Milli, he filed his lawsuit on December 5th. And the same law firm filed a lawsuit on December 17th, that's today, on behalf of the Carlton, or, Carlton, his real name, I didn't know his real name. His real name is Alfonso Ribeiros. So Alfonso Ribeiro had the really famous dance from the 90s, the Carlton.
Of course.
A couple others real quick. Will Smith had another dance called the Rambunctious, that's the emote. Marlson Webb had Band of the Bold, that was his video. Donald Faison from Scrubs. You remember Scrubs, the TV show? Yes. And then, of course, we got our guy Terrence Ferguson, better known as 2 Milli, with his Milli Rock dance. So what happens is Fortnite is selling for real money in the real world the right for people's avatars to have these dances. And the thing is, like any normal person who already was familiar with 2 Milli and the Milli Rock, immediately knew that it was him. Like they knew it. And in fact, he had never heard of Fortnite, because I got to tell you, I'm 38 years old. I love gaming, but I just never got into this one. I never heard of it before.
Right, absolutely.
I feel like maybe it's the next generation. Anyways, so Fortnite is making real money, and they're not giving these people credit, which I think is kind of one of the things that's really cutting edge. And I don't know if you want me to go into this right now, but the copyright, like the law that we know it, was written in 1976. So before 1976, it was totally clear that dance moves were not, or dances, any types of performance art, were not able to be copyrighted. And so in 1976, they went ahead and said, okay, you can copyright this. And in fact, you mentioned it, and I'm going to inform all your people out there who are performers and your artists. It's not hard. You submit an application. You can do it online. There's a $35 fee, and it's designed to be done by lay people. I mean, you can hire a lawyer. I'm happy to have you pay me to do it. but it's designed to be something that any photographer, any artist, anybody who writes, you can register your copyright. And then the trick is it needs to be a whole dance. And that's what they wrote into the law in 1976. You had to get a whole choreography, and it had to be in a fixed format, meaning it either was a video or like detailed written instructions. And then, here's the idea of copyright law. If somebody else knocked that off, you could sue them for back in 1976, imagine what they were concerned with was people like bootlegging copies of records or LPs, right? They were the people like recording television shows and then trying to resell it. Like that was copyright law in 1976. And I was talking to you about this before the show, but in 1976, if you're a 50-year-old congressman or woman, I guess, in 1976, you were born in 1926. So the idea the idea of monetizing an emote on a video game played on an iPhone in 2018, it just doesn't. And that's really where we are. The law, as it's written, clearly says it has to be a whole choreography. It can't just be a move. And what they said is that a move is like a word, or it's like a note, like a chord on a guitar or a violin. You can't. Right. So if somebody plays 3 notes, and maybe you and I recognize those 3 notes as being from a Beatles song or something, what they said is you can't copyright 3 notes. You can't copyright 3 words. You would have to copy like the whole Beatles song is like a bad example.
Right. Well, that's where I feel like, which is the reason kind of like why, I felt, inclined to bring on a professional, if you will, because I feel like, which I totally understand that comparison of not being able to copyright a dance move to not in using it with respects to like a word in comparison to a word or a chord. Yeah, that's going to limit others from doing it. But when you're talking about something as free as dance, like the Carlton, that is unique movement. This has personality. This is definable. Maybe that's even like, and I don't know anything about law. I mean, like, let's be real. But I know that you have like specific words that you use that have specific definitions to deliver a specific message, like something that is uniquely definable or uniquely, what's the word? Recognizable, perhaps. To a certain eye to where people could say that is that, like for example, I think you were making mentions of, these other dances, maybe, the moonwalk.
I think that's probably the most famous example. So when they wrote the law in 1976, what they didn't want, and they were explicit about this, is like a touchdown celebration being copyrightable, or actually what they really were focused on is folk moves or yoga moves or ballet. I don't know if you do ballet, but the different positions, right?
Of course, yeah, you can't copyright that.
You can't copyright the positions in ballet because they are known to everyone. And the moonwalk, right? I'm sure that we've all seen something on TV where another performer is doing the Michael Jackson moonwalk. And I think where we're getting cutting edge and where the law is going to either have to catch up, and we can talk about how we can change the law, but where the law needs to catch up is they're monetizing it. It's not like 2 Milli is saying that other people can't use his move as a tribute to him or as an appreciation of him. And in fact, there's a famous case going on right now. It's not really a case, but Beyonce, this is actually going back a couple of years. I found this article when I was preparing for today. This is an article from 2011, where Beyonce was doing the VMAs and she was performing, and it looked like, and people called her out for doing a move that was well known by a German artist. Somebody whose name I'm going to butcher, but her name is De Keersmaker. And so basically people were saying, hey, wait a minute, that's clearly like this move done by De Keersmaker, and Beyonce looks like she's totally ripping it off. Now, to Beyonce's defense, her video, it was the video or the performance for the song Countdown was lots and lots of little, we'll call it an homage, right? She was giving credit to lots of other artists and lots of other performances, and like basically the whole choreograph, if you want to call it that, was lots of little pieces of other types of dance.
Right.
And that's where you mentioned, like, we don't want to stifle creativity.
Right.
I don't want you to get, and I don't know how much money you have, but I don't want you to get a cease and desist letter every time you do the moonwalk. You know, like, I just don't think that's the world we want to live in. And that was kind of the idea when they wrote the law in 1976. But where we've evolved is now it's not just people having fun dancing. Even if you're Beyonce at the VMAs, maybe knocking off somebody's move, Fortnite is charging money straight up. Like there is like literally an accounting line in their back office where they can show you exactly how much money they've made selling that move.
Exactly.
No.
And this is and again, this is where I think this is something. I feel like something. I don't know what, but I feel like something needs to be done as far as for the evolution of this thing, because like you said, like, I mean, it's with all of the amazing intent that it had. I mean, what are we talking about? 40 years, you know, since it's been 42 years. And I think you hit it right on the head when you said, you know, these guys had no idea where the world was going to go to. I mean, but on the other side, I'm also very grateful where I feel like things are moving forward in a place where people are paying money, even if it's their little avatar, to express themselves. Because what we're always talking about in other episodes, etc., is just kind of just encouraging people to like, I don't know, for you yourself, like Eric, I don't know when was the last time that you know, put on a song and just decided to move. You know what I'm saying? Like we try to encourage, exactly. We try to encourage people and let people know that it's so healthy. That there's the benefits are just astronomical. Not just from an energetic sense, but from a physical sense as well. And I don't think people realize the value of that. But things like this is what's just kind of bringing awareness to things. We did an episode not too long ago about autism and the arts, etc., and how specifically dance is really like so ridiculously therapeutic to those on the spectrum. I mean, and it's just,
and also playing music.
Exactly.
Yeah.
And everything when it comes to the arts, as far as for just a medium in which a human being can express themselves. So for these types of things to come out, regardless of how they're coming out, I just want to make it clear to all of our viewers that I'm just so grateful that that they're starting to be little firecrackers. They're starting to be little things. Like I know I've mentioned about you know, Karen and Ricardo, the salsa couple that went on World of Dance, and they did absolutely phenomenal. You know, that's unheard of as of until relatively very recently. So all of these little things are definitely awesome. But, you know, with that being said, I definitely don't want it to just be bypassed, if you will. If there is an opportunity, you know, to make a difference, if there's a way that, you know, someone like me, you know, poor, you know, little casino instructor from Miami, you know, can legally put my name onto something that I spend time creating. Or, you know, perhaps you're a belly dance instructor out there, or you're a professional ballerina, or, you know, and you want to be able to monetize something from a legal standpoint. Yeah, I'm not saying that other people can't do what you're doing, but just at least I'll prevent somebody from robbing you. And I feel like,
let me dig into the law just a little bit for you guys. So if anyone out there is a big nerd and wants to look this up themselves. So first of all, the Copyright Act, 1976, it's in what's called Title 17 of the U.S. Code. So United States Code, Title 17. That's where you're going to find this. Then let me write that, brother. U.S. Code, so Title 17? Right. So shorthand is USC. But yeah, U.S. Code. If you Googled U.S. Code Title 17, you will find the entire Copyright Act, the whole thing.
Is that right there, just like that?
Yeah, that looks good.
Okay.
United States Code Title 17. So then, okay, so just to remind all you guys, Schoolhouse Rock. So Congress passes laws, they get signed or, you know, approved by the president. and then the president is tasked with enforcing the laws. So the Copyright Office is actually under the executive branch, right? So the Copyright Office, they have regulations. So they write regulations to decide how they're going to enforce the laws. Those are going to be found, and you want to type this down for them?
Sure.
It's Title 37. That's what it is, Title 37 of the Code of Federal Regulations.
Of the Code Federal Regulations.
Code of Federal Regulations.
Okay, got it.
All right.
Got it.
Then they have a third level. It's like the last level, and it goes down in terms of importance, meaning that the act is the highest level, and then the third level, which is actually called the compendium. That's COMPENDIUM.
Okay.
And so that's the compendium has the practices and procedures. And so you can actually look at how they write the rules for the people who work at the trademark office to enforce the trademark laws. There you go. So, going back to what the law as it is now, the law as it is now is it has to be a full dance, not a move. And it's got to be fixed in either a film or a video or a written description. And just so you know how long you get if you manage to copyright a dance, it's for the life of the creator plus 70 years. So
okay.
I can't remember exactly what year Michael Jackson died in, but I'm just going to make up it was 2010. So that means that we've got until 2080 where the moonwalk, if it was, that's a bad example because it's not, but we'll say Thriller, let's say it's a copyright owned by Michael Jackson, that it will be protected. And remember, the Thriller dance is a good example because that's a whole dance, right? The whole thing. So you get the life of the artist plus 70 years. That's why a lot of times you'll hear it's the estate of. So it'll be the estate of Elvis Presley or the estate of Michael Jackson who are out there actually enforcing these long after the person's gone. And so, thinking about how we can affect change, there's really three ways. The first way is we have in our system what's called the common law. What the common law means is that every judge has to respect what every other judge says. So this judge in California who's got this case with 2 million, the Millie Rock, he or she is going to make a decision. Whatever that decision is, it may or may not be appealed. And so that would go to like the next higher court. And this is in federal. So then if it gets appealed a second time, then it goes to the Supreme Court of the United States, assuming they take the case. And so the common law means that every other judge has to respect whatever that decision is. So if this judge says, hey, listen, this might not be neatly within the 1976 law when nobody knew what's it called, an emote?
Yeah.
Whatever an emote is. So in 1976, they couldn't have contemplated an emote. So let's just say that this judge says, hey, this is clearly something that should be protected. I'm going to rule in favor of the plaintiff. I'm going to rule in favor of the artist. So So then every other judge would have to take note of that. That's the common law. So if we start stringing up enough wins in favor of the artists, then essentially the law will change because the judges will have to respect the other judges in the next case and the next case and the next case.
Right.
That's number one. Number two, and this is really, I don't know how easy this is, but essentially the president can direct his agencies how he wants them to enforce the laws. So if he tells them, and here's a good example, and here's a shout out for my girlfriend. My girlfriend's Deirdre Nero. She owns her own immigration law firm here in Miami, Florida, Nero Immigration. So there has not been a single change to the immigration law since Trump was elected. Not a word. Literally, it's every word the same as it was under Obama. But what the difference is that the president has instructed his agencies different instructions on how to enforce the law. So all the changes between now and under Obama is just the president telling the people how to enforce the law. It's kind of like when they tell the prosecutors to stop prosecuting marijuana crimes. The law hasn't changed. He's just telling the people how to enforce it. So perhaps there's a way of lobbying the president and saying, hey, president, why don't you tell the Copyright Office to give more respect and more protection for the artists who have these. I don't know how practical that is, but I'm telling you that's one way of doing it. And then the last way is every concerned artist out there should reach out to their congressman or woman or their senators The congressmen and women are usually more accessible because they're more local. And then, and then at the federal level, they could propose changes to the copyright law. Again, and I think this is where we balance the right of artists not to get sued every time they do the moonwalk versus the right of artists who come up with something new to get compensated for it. Like how do we balance that? And smarter people than me will figure that out. But I think that this case is really unique because we're not saying, hey, Beyonce, you did a dance during the VMAs. We're saying, hey, company, you're selling my dance.
Right. Which is a whole nother ballgame, which is a completely other ballgame.
It's new law.
Yeah. 100%, man. And that's where, and here's the thing. I'm all for corporate growth. I'm all for profiting, big businesses profiting. I'm all for it. That's great. Especially, I don't even mind them necessarily taking advantage of, I'm sure they did their research and they're like, okay, only full dances, can be enforced upon. We're only taking dance moves, so we're in the clear.
I'm sure their lawyers told them it was fine. I'm sure that their lawyers wrote a memo that said, don't worry, you're cool. Here's the law. Right.
Exactly. Which is fine. So I personally don't feel that they necessarily, these people that are suing are really have any grounds because the law is clear. What I have an issue with, or I guess ultimately what I have an issue with is that something as unique as the moonwalk, as the Carlton, as the Millie Rock, those are uniquely definable. This is something that somebody can say that belongs to that person. And then, like you said, as long as we're able to make sure that nobody can profit on it, I feel like that's where we have a mutual, at least between you and I.
Yeah, no. But here's the problem. Words like profit, like where do we draw the line? Did Beyonce profit from using a dance move at the VMAs? Probably. She probably sold a couple extra records, maybe some more T-shirts or whatever Beyonce sells.
Right.
So that's where the lawyers make all their money, because that's great. Because if we say the word profit, like what are we defining it as? Is it indirect profit, or are we going to limit it to direct profit? And that's why we live in a complicated world, man. Just real quick. So you want to know what he's suing for? So it's a multi-count complaint. Count number 1 is copyright infringement. Fun fact, he filed to register his copyright the day before he filed the lawsuit. So it's not even registered. It's like, and here's the problem. I think that under the existing law, if he had tried to register this move, I think his move is from 2014. I think if he had tried to register the move when he created it in 2014, I think the Copyright Office would have denied the application. I just think that's what, and listen, they're the little people who work at the Copyright Office, they're just like me and you. They work a 9 to 5 and they have to follow the rules of their job. So the rules of his job says I can't copyright moves, whatever. I'm just following my rules. So he's suing for permanent injunctive relief to prevent the defendants, Fortnite, from and their officers, agents, employees, and all related persons from using the Millie Rock and engaging in other acts in violation of the copyright law. So basically, they want him to take it off the website, or I don't even know. Is this a website? Is it an app? It's a game.
It's a game. I think it's a download. It's a downloadable game. I don't even think there's a freaking CD anymore. I don't even know how that works.
We should see. If any of your fans out there listening know how this works, please enlighten us, because I feel
yes. I was just gonna say, for those of you that know the titles of these dances that we're butchering, please comment, help us out here so that we can. Well, we see everything that you guys are seeing here, so please, by all means, if you're familiar with this, or by all means, if you play Fortnite, how many dances are there? Please, by all means, let us know.
Spent money on dances? You can admit it. I want to know.
Right. Yeah, absolutely. All I know is that there are a lot of people playing this game, and a lot in their 30s too. In their 30s playing this game, and obviously, of course, everyone younger too as well.
So here's a fun fact. They made $380 million in May 2018. Just real quick to finish. So he's also suing for damages, including attorney's fees, any profits obtained by the defendants as a result of the infringement in an amount to be proven at trial. Basically, they're going to subpoena all the financial records if the case gets that far. Now, sure. I'm gonna predict the future for you. The defendants, the Fortnite, are going to immediately file a motion to dismiss. They're going to say, "Listen, judge, throw this out now," and they might even be so bold as to ask for sanctions for saying, "Hey, lawyers, you should have known that you couldn't even bring this lawsuit in the first place. The law is clear. Moves, choreography, you know the difference." Right. They're also asking for punitive damages. And here's the words in the complaint. It says, "The defendants acted fraudulently, willfully, and with malice, and therefore 2 million is entitled to punitive damages according to proof that will be given at the time of trial." So there you go. That's just count one. I stopped reading. I think he has 8 more counts. And they did it in California, which is interesting because the plaintiff, our artist, he lives in Brooklyn. His lawyers are all from New York also, by the way. The defendant, this company, is from North Carolina. So I wonder if there was a little bit of forum shopping. It's well known that the federal court out in California tends to be a more liberal court. So who knows if they did some forum shopping and they picked a place, in California where there's going to be more protections for artists than, I don't know, maybe if you did it in Texas or Florida.
Right. Wow.
Okay. So
350 million in May.
In May, I think it was over $1 billion already, like way past $1 billion. I haven't looked at the latest numbers, but it's silly, It's and it's actually kind of cool. I don't know if you're into gaming, but basically they had a hackathon.
100%.
They had a hackathon where they invited a bunch of game designers and they put them in a room together and they said, "All right, you guys have 24 hours, come up with a game." And somebody said, "Why don't we combine a shooter with Minecraft, which is like building worlds and killing people?" And they like put them together.
Yeah.
Crazy.
Yeah. And which I think if I'm not mistaken, Fortnite is a kid's version of a super popular game as well, which is like the adult version. Oh my gosh, I forget what it's called. For those of you that are watching, if you know what I'm talking about, I think it's oh man, it's like letters. I forget.
Well, I'll tell you what. Listen, I don't have kids, but there's so many ethical and moral things about targeting things to sell to children because they're using their parents' credit card. You know what I mean? Like they got mommy's iPhone and they're like, "Buy more V-Bucks," or whatever they're called. V-credits.
Yeah. Just like that. Just like that too. Let me see if I can find the name of this game here. And it's Fortnite, and is it E? Oh man, I forget what it's called. For those of you that are watching, if you know the derivative of the game of Fortnite, the one that it came from, my brother would be able to tell you. I don't know it. But yeah, there's definitely a few.
In the article that was posted on Newsweek.com today about the Carlton dance being in the lawsuit today, they have made over $2 billion on this game as of today. The information, at least in this article. Oh,
that's what you're looking at. Okay, so $2 billion on just the dances.
No, on everything, on everything they sell. But what I'm saying is, this is deep pockets. This company, this game, they have. And here's the other thing.
I think that I think they're the number one. They're the number one profit there as far as for games is concerned. They developed the most revenues ever by a long shot.
Yeah, in the history of games, in the history of gaming, and so as of today, according to this article, $2 billion. And I think, like you said, you can buy outfits. You can buy upgrades to your weapons. You can buy these moves. There's a lot of things you can buy. So I'm not saying that they've made $2 billion off of our boy 2 milli. I'm just saying that it's, first of all, clearly profitable. And I can imagine that if they haven't already, they've got an army of lawyers ready to go. This is going to be interesting to see how it plays out.
Right. No, 100%. So yeah, so I feel like as with respects to this specific case, as even if they don't get anywhere, I'm grateful that they're even trying. Even like I said, like you said, like they're probably not going to get anywhere. But just the controversy alone, I think is really, really helpful to artists. I mean, it got me thinking. It's like, hey, wait a minute, like, this is there room here? Can I, take the time to, like any other professional, to do enough research to then be able to create my own little niche, to then be able to do a little something for myself, call it my own. And whenever that anytime that there's money opportunity with regards to it, that I'm the only one that's entitled to that. So it's more so like you had mentioned, the steps in order to be able to evolve the law, I think is the word, evolve the law, so that it's a little bit more form-fitting to what is it that we're talking about now. And maybe not necessarily just for the dances. Maybe we need to talk about the arts in general, the copyright law for the arts in general. I don't know. Obviously, of course, I'm not a musician. I'm also not a painter. I'm not a sculptor. But I'm sure that there is some room and there's some interest when it comes to that as well, because I think everybody, when they're trying to make a living for themselves, I think that they value that.
So, I mean, let's be clear for a second. There is copyright protection if you create a whole dance. And so if you record it and somebody else knocks it off, I'd be happy to sue them for you. If you write a video, or if you produce a series of videos teaching people the salsa, for example, and you're selling it online, you're selling it on the Home Shopping Network, whatever, and somebody knocks that off, or they knock off your teaching techniques, 100%, the law is going to protect you today, as written in 1976.
Okay, so time out on that. So that's a big one. So you're saying instructional purposes, like let's say I was to title my teaching methodology.
Absolutely. Sure.
Okay.
And that's copyrightable. In my bookshelf down there are a bunch of instructional books for business professionals, and they all are copyrighted. Dale Carnegie, he's got his whole line. Sandler, Maxwell, like these are all well-known. They've written books, they've done videos. Right. We've all heard of Tony Robbins, right? If you knock off either his techniques or just straight up, if you're trying to resell his productions, the law will go after you and will protect him. But that's obviously different than what we're talking about here. And so I want you to know that there are ways under the present law for artists to be compensated for their art. It's just the present law is 42 years old. Like the present law can't imagine monetizing little kids using their parents' iPhones and buying dance moves.
Right. Which is essentially what they're doing. They are literally purchasing dance moves for their computer versions of themselves as they build worlds and kill other virtual versions of other people.
It's incredible to think about.
It's absolutely mind-blowing. But the fact is that we're talking about how many billions of dollars again?
$2 billion as of today.
And absolutely incredible. Absolutely. And I think when we're talking about that kinds of money or that kind of power, but I think Epic Games knows it, and we go back to that again. Good for them, good for them. At least that's the way that I see it. It just goes back to, I don't think that the next game should be allowed to do that. You know what I'm saying? Like I feel like learning from this, this case. Like I think, like you had said, this guy, what's his name, Alfonso, said that he had put in the copyright application the day before he filed the suit.
Oh, actually, that was 2 Milli. 2 Milli put his in the day before he filed the suit, and so did Alfonso. Like they both are using the same law firm, and obviously they were like, "Hey, quickly go do a copyright application." Just so you know, when you do one of these applications, it takes a few months to get processed by the Copyright Office, but you immediately get you get a serial number. So what they did is they're suing under the pending application. And
got it.
just so you know, there's another controversy that's very related, and I think has also been involved in some lawsuits. So apparently NBA 2K, so this is the basketball game.
Yes.
Same thing. There's dance moves in the game that allegedly are copying other artists.
Okay.
So that's something. And then there's kind of a, I feel awkward talking about this. There's a whole angle where they're saying that these white corporations are taking advantage of black artists. And
yes.
If you just Google, literally go to your computer right now, Google 2 milli. It's the numeral 2 space MILLY. Don't put anything else. If you just Google 2 milli, right there, you've got Epic Games sued for swiping Millie Rock. Fresh Prince star sues Fortnite over Carlton Dance.
Yep. I see it all.
And if you keep going down, you'll start seeing articles on this whole idea of white corporate America taking advantage of the black artists.
Right.
I don't feel comfortable commenting on that because I'm white.
Right.
But anyways, I think it's not, instead of making it a racial matter, I think it's really, and it's something you commented on, it's a question of people being educated and uneducated. And I don't mean about anything other than copyright law. So there's a lot of artists out there, whether you're Cuban or you're Colombian or you're Mexican or you're, a country music singer from Tennessee, who don't know their rights.
Absolutely. And I think that's standard. And I think that's standard. And obviously, of course, these bigger corporations, regardless of, in my opinion, regardless of race, they obviously, of course, have the resources to be able to look this stuff up. They have an intention. They have a reason behind it. There's a profit behind this research, this information that's valuable to them. Whereas obviously, of course, the person that's creating it, the artist, little old me or little old us, if you will, the dance community, we're just dancing, we're just creating, and Salsa Kings and the Alliance and everything that we stand for, we've been trying to, try and merge, entrepreneurs and business owners with the artists to be able to try and push this thing up because, artists, I feel like for a long time, kind of feel alone, when it comes to this thing. And we're just trying to do what we can to sell our little classes or whatever to live the dream of doing what we love, but I really feel like there is a place to be able to, actually take it to the next level with, and if we have this type of support, and going back to the education too, if we know what is it that we could do and what space that we have to be able to protect ourselves, and that's ultimately going to help as well.
Did you put a link to the complaint?
No, I did not.
All right, so share that. And anyone out there who's curious, so it's double spaced, it's quick reading. The first page, you skip it, it's just the caption of the case. And so basically pages 2 through 10, call it. So it's 9 pages of double spaced type. That's the summary of the whole lawsuit. Everything after page 10 is legal stuff where they're putting forth what we call the counts or the causes of action. But in the beginning, you have what basically a summary of what each party did or didn't do and what the allegations are. So you can have in the lawyers representing 2 milli, let me give you his real name to give him props. So his real name is Terrence Ferguson. And so it gives you the whole background. It tells you who he is, where he came from, how he developed the song, how he started, popularizing it. And then it tells you the whole background on this Fortnite. So basically everything I know about Fortnite, I read in this complaint and in a couple other articles. I haven't had a chance to read the complaint yet that was filed today. But what my understanding from what I read is that it's almost virtually identical to this complaint here. It is the same lawyers. I think it's the same attorney who filed it at the end. Let me give her props too. Her name is Carolyn Beck, and her law firm is Pierce, Bainbridge, Beck, Price, and Hecht, which is a big mouthful, LLP in New York.
Sure.
And she's one of their California lawyers, actually in their Los Angeles office. So.
Okay. So let's go And we've actually been on here 45 minutes already. Incredible. So like we said, they're probably not, they probably don't have too much grounds. But that's besides the point. It's more so like I said, the perhaps the evolution of the law. Would we have to be, in order to challenge it, would we have to create an entire would we have to propose the exact solution?
You know, there's an old saying from the law, and I remember this from law school, is that bad facts make bad law. And let me tell you why this case has bad facts. So
Okay.
with all due respect to you and to your colleagues, I don't think you're famous, at least not famous on the level of Beyonce or Michael Jackson or the Carlton or Will Smith or even this guy 2 Milli.
Right.
Which, to be fair, I had never heard of 2 Milli before this, but apparently he's got a following. He performs professionally. He can fill an auditorium. He made it. He's selling records and albums, whatever. And so the reason this is bad facts is today you could come up with a truly unique dance that nobody had ever come up with before. And you could record it, right? You could put it on YouTube. But until you became famous, it would never be associated with you. The reason these are bad facts is because this guy was famous either because of the dance or was already famous, and then the dance became famous because of him. So that's why I think that this case is kind of, it's on the edge, because if you of course, Salsa Kings, if you recorded something and put it online, and then if Fortnite copied you a minute later, right? A minute later, they're selling the Salsa King experience as an emote.
Right.
I'm not sure, because they're not stealing your notoriety because you don't have any. Right. I'm not, I promise you, I'm not trying to be disrespectful. I'm trying to
not at all. Don't worry about that. No, I'm trying to get the facts here. Please continue.
Right, I'm trying to make a point. My point is that it was because of the notoriety of the famous people that they have a claim on that dance, not the other way around. It's not because it's a truly unique dance that he has a claim on it. It's because he already is recognized that he has a claim on it. That's maybe where I think it's murky. I think, to say the least, this would be very interesting to see where the developments are in this case. And if you could do it, I would set, I think on Google News you can do this. You can set an alert whenever there's a new news article on this topic.
Yes. Yeah, the Google Alerts, I think they're called. They're actually called Google Alerts, if I'm not mistaken. But yeah, no, okay, so then, right, but okay, so with what you had just said, the as far as for notoriety is concerned, the reason why this is kind of blowing up is because they're already have some type of fame to them, if you will.
I don't think it would have even made the news if a no-name person was alleging that their dance got knocked off.
I agree 100%, which is why I go back to me being grateful for them to even stir a little bit of something in there, right? Which is absolutely phenomenal. Now, the I'm not so much concerned, like I said, about these cases, but more so the future in this. And like I said, how would we have to be able to? Would we have to propose the exact solution for us to get any type of attention first? Because I feel like that's going to require a lot of professional guidance, if you will.
It's interesting you say that. So going back to what we were talking about before, listen, if you create something unique, you need to record it. You should definitely try and copyright it. It costs $35. I mean, what do you have to lose?
Right, sure.
And as quickly as you can learn to do one application, imagine a photographer walking through a field. He takes 50 pictures. It's not going to be that hard for him to record 50 copyrights if he wanted to protect all 50. It might cost him some money, right? What's 50 times 35?
Right.
But, so I think we're at the I think with this law, or this case, if it can do anything to advance the art, it would say that if somebody else is profiting off of somebody else, that they deserve to at least get the recognition or a cut of the profits.
Right.
I think that's where this law, and this is how, when I said earlier, the evolution of the law. So let's just imagine that 2 Milli wins. Let's just imagine he wins. right? And so there's a ruling by a judge that says that this company owes that guy money because they stole his dance. What's next? And that's always where we go with the law. Where do we go next? Does it mean that everybody with a unique dance is going to start searching out there for everyone else who's trying to make money off of their unique dance? And there might be yes. There's a thing in patent law called a patent troll. Have you ever heard of this? A patent troll?
No.
Okay, so there'll be like some obscure company that makes some weird patents on like a tiny little piece in like some machinery, right? And they might even be out of business. They're gone. They patented it in the 70s. Well, what the patent trolls will do is they will buy that patent, maybe for pennies on the dollar. And then what they'll do is they'll go out there and look for anybody and everybody who might be infringing on that patent, and they'll just sue them with no questions asked. No demand letter, no, hey, let's make a deal, let's come to an agreement. They'll just sue. And if you're, a humble company out there and you get sued all of a sudden for patent infringement and patent troll, that's a derogatory term. But what it means is they have no vested interest in the actual invention. They don't really care. They're just going to look to make some money because they buy these portfolios of patents. So imagine if we could have copyright trolls who buy portfolios of dance moves and just, have little people in India sitting there searching the internet for anybody. And I'm just picking on India because maybe it's inexpensive labor, but they're searching the internet for anybody using that dance move. And then they're just firing off lawsuits. And so the big criticism of the patent trolls is that they're blocking up all the courts because these are lawsuits that have no real meaning because nobody actually cares, but they're technically following the law and they're just trying to make a quick buck. So imagine if that becomes the future of like people buying portfolios of dance moves to just file copyright infringement lawsuits.
Right.
Kind of crazy.
It gets so sticky. It gets so tricky. A lot of people get involved. A lot of opportunities for people to try to make money for other than the intention or the purpose, the initial intention or purpose.
And don't forget the fine line. I don't want every artist out there who does a dance move to get a demand letter in the mail, right? If you're a hip hop dancer and you inadvertently or advertently do a move that's similar to somebody else's, are you going to get sued? And so the way the law is now, you shouldn't. That's the way the law is now. The way the law is now, you do a move, you're protected, right? You, the person copying can copy, and you're not going to get sued. And so it's interesting to see, where does Fortnite change this, if it does at all?
Right, if it does at all. Exactly. Okay, so then, like I had mentioned, like I feel like if we're wanting to move forward with this, if we're trying to make that happen, and
wait, let me ask you. Hold on. Let me ask you the question. What do you want to see happen?
What I want to see happen is for someone like me, not necessarily me, but someone like me who's trying to promote something, promote an art, promote X. I don't want them to be limited on what is it that they can do because they feel that someone else can steal the idea and profit off of it. I want someone, because I have a few tricks up my sleeve too. I'm literally we're talking about, as far as tricks up my sleeve in an artistic sense, that nobody's ever seen before, which is obviously, really exciting stuff. But I want to go about it in the right way to where the second that somebody sees this, it's very possible, that they'd be like, okay, let's do that. Boom, let's go. And then, someone with 10 times more money than me, they just flick their fingers and then it's done, way, way better. I obviously, of course, want to be able to create. I want to be able to be in a world, and those coming after me to be in a world where they can create something new and unique based on their studies, based on their research, based on quality, even if it's in the origination of folk. Like you had said, you can't copyright folk, but you can obviously evolve it to where is uniquely identifiable as something new and fresh. And if it's close, then no, but if you can say, okay, that this is, I don't know what those laws are going to be to, by line that's going to say, okay, this is what qualifies it to be uniquely identifiable. I don't know. But that's what I would want. I would want to be in a world where I don't have to hold back my creativity, and with enough education to be able to smack my name on it before I actually go about and distributing it in a way that's going to benefit me and my family. Because ultimately, that's what we're talking about. I want the arts to be in a place where it has enough income opportunities for anybody to be able to support their family like anybody else in any other career or industry.
So let me give you a counter argument real quick. So the counter argument is that these intellectual property laws are anti-competition. They are protecting the vested interests. They're protecting the Mickey Mouses of the world. They're protecting the giant corporations and not letting artists like you innovate and not letting artists like you be artistic. And so anything, and I think you mentioned your background's Cuban.
Yes.
As far as I'm concerned, anything that's anti-competition is bad. I'm a little bit of a libertarian. I think giving the right for Walt Disney to own a stupid mouse for 70 years after he dies, and you know that on the 69th year they're going to petition Congress and change the law again. You know they're going to. They're going to own that Mickey Mouse until the end of the world. And that's, it's just a mouse. How long can you own a mouse? And I know that I'm going a little bit off topic, but
sure.
All of these things, all of these copyrights, patents, and trademarks were designed originally to strike a balance between rewarding the innovator, but then also fostering creativity and innovation. And so every time somebody comes up with a clever mouse cartoon, they're probably going to get sued. And so you've essentially, and it didn't used to be 70 years. It used to be 20 years after the death of the artist. And they changed it to 70 because of Mickey Mouse. And so now there's an entire area of art, which would be cartoon mouses, that you essentially can't go into because of these laws. So these laws are stifling competition. They're stifling innovation. So the idea that, A, we want to reward the creator, I agree, but to what cost? For the rest of time, is nobody, can you show us what the Millie looks like? Come on, do you even know the arm move? It's something I
couldn't even tell you, to be honest with you. I couldn't.
How about the Carlton? Do you remember the Carlton?
The Carlton I do. Yes.
Right, I won't ask you to do it on video, but there you go. So now you're gonna get a letter. So you just did a podcast where you just copied the Carlton. Are you going to get a cease and desist letter from some big law firm in New York City?
There you go.
Yeah, and so and that is the trouble and the balance, and oftentimes why the law doesn't change. It's kind of like in 1976, I think they were addressing a legitimate concern. In 1976, you could not protect any performing arts. Okay, so they said, okay, listen, if you have a recording of a choreographed song, now it's protected. And so that was 1976, addressing a real concern. And so maybe the reason the law hasn't changed since then is because where do we draw the line? Where do we draw the line between allowing an artist to innovate and maybe even imitate? Because that's a word that you haven't used and I haven't used yet. Imitation is the highest form of flattery. In fact, imitation, parody, right? Can President Trump sue SNL because they use his likeness as Alec Baldwin, right? That's parody. In fact, Weird Al Yankovic was copying all of those Michael Jackson songs.
Yes.
Remember Just Eat It? So
yeah. Absolutely.
And guess what? He was protected under copyright law because our arts allows for imitation as long as there's, it's an homage, as I mentioned with the Beyonce thing, or it's substantially different where it's clear that it's a parody. We allow parody in our society. So anyways, obviously, we can't do this. We can't have this podcast go on forever. I think we're
right.
But this is really interesting for all your listeners out there. Don't be afraid to pick up the phone. You can call me. You can email me. Obviously, Salsa Kings can put us in touch.
100%.
I'm free to answer any simple questions, and hopefully, there's a way we can protect your right to innovate.
Absolutely, man. Eric, thank you very, 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 very much.
Yeah, this was good.
I will certainly be tuning into this This is for those of you that are watching, or those of you that are listening. This is cutting edge stuff. This is we're striking on history right now. Like, this is, depending on where this goes, can really set the standard or set the mark or the platform of a new dance world, like literally. And obviously, of course, it also depends on the follow-up, of what people like us do with this new information or with these new cases, etc. I'm always about people power, and if enough people come together representing something, obviously, of course, with respects and understanding everything else, that we can change stuff.
If every artist in America wrote a letter to their congressman or woman, I wouldn't be surprised if we could make something happen.
And there's no reason why everybody couldn't pick up a pen and go ahead and do that, or nowadays on a computer or a laptop. As long as we're not waiting for everybody else to do it, but we just do our own part, then we can go ahead and make that happen as well. So definitely super exciting stuff. Like I said, I'll be keeping in touch with this. Eric, I'll be keeping in touch with you. Again, to all of our viewers, etc., feel free to text the word join to 69922, so that you can receive push notifications to your phone about every time that we go live, so that you can go ahead and check that out, so that, again, you'll be receiving a link directly to the Facebook page in which we broadcast everything. Again, that's the word join by itself, JOIN, to 69922 is the phone number, and you'll go ahead and receive that directly. Eric, once again, 1.5 million thank yous for you and your time and your expertise. Much appreciated. Little old us, small people like us, we really appreciate.
Listen, I'm available whenever you want, and this was good times. I'll be sure to share it to all my followers, and hopefully we'll get some nice feedback.
Wonderful, man. Thank you again, Eric. Have a wonderful night. Thank you guys for tuning in as usual. Andres Fernandez and Eric Gros-Dubois signing out.
Bye-bye.
Bye-bye.